New court filings by the prosecution in the Kouri Richins aggravated red rum case paint a picture of strongly worded language, prompting Richins' defense team to characterize them as snarky screed of personal attacks against them for doing nothing more than complying with their constitutional duty to represent their client. Richins is accused of fatally poisoning her husband, Eric Richins, with fentanyl in March of 2022 at their Eastern Summit County home in Camas. I think it's Camas. Sorry. It's in Utah. Just as their trial is about to get underway in April, the Summit County Attorney Margaret Olson and Deputy County Attorney Brad Bloodsworth filed oppositions to the defense team's motion to suppress. Those documents are strongly worded, and now Richins' team is accusing Olson and Bloodworth of violating a section of the Utah Rules of Professional Conduct for Attorneys, calling for sanctions against the Summit County Attorney's Office and for the prosecution's filings to be struck from the record. Richins' public defenders, Wendy Lewis, Kathy Nestor, and Alex Ramos, appear to assert that Olson and her prosecution team have a problem with the defense doing their job and have made it personal. This stems from a recent disclosure by Olson to the defense. Richins' defense team called into question the accuracy and possibly the truthfulness of lead detective Jeff O'Driscoll's previous testimony on January 3rd of 2025 when he was asked about going into Richins' home on April 14th of 2023. On January the 8th of 2025, the defense filed a motion to suppress the statement that Detective O'Driscoll obtained from Richins during that interview at her home. The defense filing shows that the grounds for the motions to suppress concerned whether Richins or her former attorney had asserted her right to an attorney prior to the interview and whether the April 14, 2023 interview violated her Fifth or Sixth Amendment right to an attorney. The reply to the state's motion opposing the reopening of evidence says that on January 21st of 2025, when the prosecution was preparing Lieutenant Justin Hemingway to testify at a suppression hearing, Lieutenant Hemingway shared his recollections of conversations that occurred among law enforcement officers involved in the Richins investigation prior to Detective O'Driscoll's interview of Mrs. Richins. These conversations dealt specifically with the fact that Mrs. Richins was represented by counsel and whether or not they could proceed with her interview in light of that being known. Attorney Kathy Nestor asked Detective O'Driscoll again while under oath during the January 23, 25 suppression hearing whether he knew Richins had a lawyer at the time he went to interview her, and he answered, "No, I did not." It further says the prosecution team remained silent during this testimony despite knowing about Lieutenant Hemingway's potentially inconsistent memories that were revealed to them only 2 days before. What's more, it says prosecutors never tried to correct the testimony during redirect and did not call Lieutenant Hemingway to the stand. On January 31st of 2025, Richins' attorney says prosecutors told them outside attorneys had been brought in by Summit County to investigate a possible inconsistency between Detective O'Driscoll's testimony at the suppression hearing and the recollection of Lieutenant Hemingway, and that the results of the investigation would be produced. On February 6, Richins' defense team received an email with a summary of the internal investigation. It says the summary showed that at least 3 witnesses confirmed that the conversations took place about whether Richins could be interviewed despite having an attorney, and the conversations were at the direction of Lieutenant Hemingway, who was Detective O'Driscoll's supervisor at the time, adding that one of the witnesses was an employee of the Summit County Attorney's Office, and this employee was advising law enforcement whether they could proceed with the interview. The defense filing then raised the following concern. The fact that an attorney connected to the prosecution may have directed that the interview of a represented individual should take place outside the presence of her counsel raises entirely new legal issues that were not addressed during the first suppression hearing because this fact was known only to the prosecution at the time. Richins' defense team then filed to reopen the hearing so witnesses could testify under oath about what was known by law enforcement and the county attorney's office at the time Richins was interviewed at her home in 2023. The defense characterized the county's attorney's disclosure to them as giglio material. Giglio material is any information that the government has that could call into question the honesty of a government witness's testimony. So on February 7th, 2 News Investigates left messages for County Attorney Olson asking for a response about accusations by the defense team that the testimony of Detective O'Driscoll was inaccurate or potentially untruthful. We did not receive a call back from Olson, But we did receive a statement from Sergeant Skylar Talbert, the senior public relations liaison for the Summit County Attorney's Office. They issued a full denial. It says the detectives involved in the Kouri Richins matter have always conducted themselves ethically and testified truthfully. The defense's motion filed last night suggests otherwise is grounded in neither fact nor law. The motion's suggestion that a particular detective testified untruthfully is irresponsible. The state will respond fully on the record at the appropriate time as provided in the rules. It is highly unfortunate that the defense in this case repeatedly chooses to malign individuals instead of focusing on substance and evidence. Last week, Olson and Bloodworth filed a series of oppositions to the defense motions, calling the motion nothing more than the defense counsel's latest implementation of current and former defense counsel's long-standing strategy to publicly malign honorable people to influence potential jurors. It's a cheap litigation trick, no more, no less. This strategy holds no place in this serious proceeding or our profession. On Tuesday, Rich's defense team filed a response saying that the prosecution's faux outrage is utterly bewildering, as they are the ones who felt compelled to make the disclosure. Additionally, it says that the county attorney's office got the summary of the internal investigation sealed and accused prosecutors of trying to shut down a public hearing and have resorted to call defense counsel desperate and their arguments to be poppycock. It says they will not sink to that level and will continue to do what they need to do to protect their clients' rights and hold the prosecution accountable for their actions. Richins was back in court on Friday as part of a hearing over the selections of jurors for their trial. At that time, the judge did deny the defense attorney's request to reopen an evidentiary hearing in the case. So there you have it. The defense has been shut down. So what comes next? Well, I'm sure there will be something before the trial begins in April, so you guys stay tuned. Thanks for watching. Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.